Hello, and welcome to the Fort Jackson Legal Assistance Office. I am Captain Reyes, and today we're going to talk about the Financial Liability Investigation of Personal Loss, or known as the FLIPL. If you have more specific questions or need further information, you may request an appointment with a legal assistance attorney. A FLIPL is an administrative investigation that is conducted to determine whether you should be held liable for the loss, damage, or the destruction of government property. At the end of the FLIPL, there will be a decision over whether you should have to pay for the property loss. In a situation where the amount of loss is less than 1 month's pay, the command may ask you to sign a DD Form 362 or a Statement of Charges. A Statement of Charges is a form which acts as an admission of liability for the loss or damaged property, and it serves as an agreement between you and the command to pay for it. The command cannot force you to sign a Statement of Charges, and if you sign it, it must be voluntary. A FLIPL comes into play when there is a genuine dispute as to the responsibility of the loss, or when there is a dispute as to the amount to be charged. If you do not sign the Statement of Charges, then the FLIPL process starts when the appointing authority, generally a lieutenant colonel or above, appoints a Financial Liability Officer, or FLO, to investigate the facts surrounding the loss. The FLO will generally be a commissioned officer, warrant officer, senior non-commissioned officer, E7 or above, or a civilian employee, GS7 or above. The FLO will be senior to the individual who is subject to the potential liability unless military circumstances require otherwise. The FLO will then investigate, conduct interviews, and ultimately make initial finding as to what happened. A copy of those findings will be given to you, and you will be given 7 calendar days to prepare and submit a rebuttal back to the FLO. If the findings are mailed to you, you will be given 15 calendar days. Once you submit your rebuttal, the FLO will review your statement along with the findings and then make recommendations as to who should be held liable and for what amount. Before a FLO can recommend financial liability to the appointing authority, he must determine that you acted unreasonably or improperly, and these actions caused the loss or damage to the property. The recommendation is then forwarded to the appointing authority. The appointing authority will review the FLIPL, review the action taken by the FLO, and either request more investigation or agree with the FLO findings. The appointing authority will then forward to the approval authority, usually a colonel or above, who has the authority to approve or disapprove the FLO's recommendation. Before making his decision, the approving authority receives a legal opinion that the findings are legally sufficient and that the FLIPL was conducted in accordance with AR 735-5. In order to find liability, the approving authority must find that there was a loss, damage, or destruction of property. The respondent had a duty or responsibility to take care of the property, the person failed to carry out that duty, or they breached that duty, and that the person's failure led to the loss, proximate cause. Once the approving authority has made a decision to assess liability, he will notify the respondent. The notification will be in memorandum format and will inform the person of a right to request reconsideration or appeal the decision. A person who is held liable has 30 days to request reconsideration of the approving authority's decision. If you decide to appeal, the request goes back to the approving authority, skipping the FLO and the appointing authority, and if the approving authority decides to continue liability, he or she will forward the request to the appealing authority, which is the next higher commander in the chain of command and usually a general officer. The appeal authority will review all the facts, rebuttals, statements, and recommendations and will issue a final decision. Once the approving authority renders a decision holding you liable, there are still several options to avoid losing pay. If you are enlisted, you can request remission or cancellation of the debt. Civilians can request a hearing, and all personnel can request an extension of the collection or petition the Army Board for Correction of Military Records, ABCMR, to reverse the chain of command action. Here at Legal Assistance, we can help you prepare your rebuttal and request for reconsideration. Before an attorney can see you, you must have a copy of the FLIPL packet so your attorney can review it. Please bring a written draft of rebuttal statements or a request for consideration. Your initial draft should be a story written by you, explaining all the circumstances surrounding the FLIPL. At the end, you let us know why liability should not be assessed. Please be aware of the deadline for submitting your rebuttal request, and your attorney will need 5 to 7 working days to help you prepare your documents. If this will put you beyond your deadline, you will need to get an extension from your FLO. If you have any questions concerning these matters or need help preparing your rebuttal, please call the Legal Assistance Office at 803-751-4287. Thank you.